All right. Just want to say good morning to those of you like me that are in the Mountain or Pacific time zone, or if you're joining all the way from Hawaii or Alaska, good wee hours of the morning to you. And thank you for joining us for this webinar that's being put on by B&L and also Berkshire. I'll go ahead and introduce myself and then turn it over to Elizabeth so that she can introduce herself and get us rolling. So my name is Thomas Carnahan. I'm an industrial organizational psychologist, and I'm also the manager of compensation services at Berkshire Associates. What I and my team does is a variety of IO psychologist nerdium. We do job analysis, job evaluation, market analysis, pay equity, anything that impacts really the employee life cycle we can do. And we are proud to be a partner of Berenzweig Leonard, and I'm excited to do this webinar with Liz.
Hello, thank you so much, Thomas. I appreciate that introduction, and good afternoon to all of the East Coasters in Central Times. I am joining from as our East Coast contingent while Thomas is holding it down there in Colorado. My name is Elizabeth Payne-Maddalena, or Liz. I'm a senior associate attorney here at Berenzweig Leonard in our employment and corporate business practice. So what we do is we do a variety of business and employment related matters, everything from pre-litigation matters or non-litigation matters, such as employment agreements, employment handbooks, and other kinds of employment matters like that, or contracts, as well as we do of course, litigation around those issues. We also have other practices within our firm that deal with intellectual property, M&A. So a wide, robust area of business practice in our firm. Just as a reminder to everyone today, this is being recorded. This presentation is being recorded. A copy of the recording is going to be sent out to all of the attendees. So you will get a copy of that within the next week or so. And as Rachel mentioned, chat is open for anyone who wants to ask questions during the presentation today. We may stop to answer some questions if they are as we're going, but otherwise we'll try to answer as many as possible at the end of the presentation. So with that, let's get started on what we're here to talk about today. I'm here to talk about the pay transparency and recent pay equity laws involving pay transparency that are being passed across the country. Thomas is to talk about how to prepare for those laws and how to approach those internally through various methods. For the laws that we're seeing passed, these are all on a state level. And what we have seen is across the states and across the country is there's this increased attention toward gender and racial pay gaps, especially in inequities. I'm sure you will hear about that quite frequently on the news. We may have lost the presentation.
Yeah, I'm working on that. That's weird.
No worries. Well, while you're working on getting that back up, I'll just continue providing the brief overview of the legal aspect. So basically, many states have gone ahead and taken the initiative to pass certain kinds of laws designed to address these gender and racial pay gaps, which has created kind of a patchwork of laws across the country that we'll be going through today. Just so everyone is aware, today we are only talking about the states which have laws already in place or going into effect as of today. We're not talking about any pending legislation. So those will certainly be on the lookout for those in the future and expect to hear more in the future on those. But as of today, just to keep everyone from being bored to death, we'll be focusing just on the states with laws already in place. All right.
Let me know if it's back.
Yes, it's back.
Excellent.
All right. And a brief disclaimer, of course, because we lawyers always love our disclaimers. As you can see, this presentation is based on current state and federal laws, which are subject to change. None of the information presented in today's webinar is legal advice and should not be construed as such. So, all right, let's talk about the first of the two kinds of laws that we're generally seeing that has to deal with pay equity and pay transparency. And that would be these laws that require employers in general to provide salary and benefit information to current or prospective employees during a hiring or promotion or transfer process. So this is, we call these pay transparency or salary transparency laws. These kinds of laws generally require employers to provide salary or compensation range for in a position or a job posting to applicants or current employees who are trying to receive a promotion or a transfer, or even sometimes just upon request. We'll get into that. And the most, I guess you could say that the ones that have probably generated the most buzz are the ones where this information is required to be put in the job posting itself. Colorado made a lot of a buzz over the last couple of years by creating a new law called the Colorado Equal Pay for Equal Work Act, where what these laws do and what they say is in your job postings, the actual postings that you put out to applicants online, on your website, wherever else you're putting those out, you have to include certain information such as salary range, benefits such as 401k, health insurance, etc. Commissions, guaranteed bonuses are usually included. Some states include even discretionary bonuses. Colorado also now requires that you, starting in 2024, you will have to include progression paths for the position. So how that position, where it can kind of the tiers that go on past where it for promotion and such. Mm-hmm. These are all the kinds of information that are being required to be disclosed. And this map, as you see on the screen, these are all of the states that as of right now require you include this information in your postings, your job postings. So California, Colorado, Hawaii, starting in January 1st of next year, Illinois, starting on January 1st of 2025, New York, starting in a couple of weeks, September 17th, 2023. They want it to be special and not start on the first of the year. Washington State, Jersey City in New Jersey, and then Cincinnati and Toledo in Ohio. So these do apply to remote positions. Now, oftentimes this will depend on how large the company is. There are size requirements, and those vary state by state. So it'll be important to look into how this works state by, what the size requirements are. But for Colorado, it's the moment you have one employee. So if you have one employee working in Colorado, you're going to be subject to at least part of Colorado's laws involving job posting disclosure. And that does mean that you need to start including the salary, benefits, and other required information in your job postings for Colorado opportunities positions or remote positions, which could be performed in Colorado. So this is something that creates a large, kind of wide-reaching effect for employers, because nowadays, as you guys know, a lot of you have remote employees or employees who move around the country. You don't always need your employees to always be working in the same office, same state as you. There can be varying reasons as to why you would want employees across the country. What this does mean, though, is that every time you have an employee in a new state, you need to make sure that you're operating in compliance with those state laws, and that can have these wide-reaching effects throughout your company.
So one quick thing, because I definitely heard you address the question that we got about remote employees. And I know I've seen personally, like with Colorado and California were kind of the law of the land before Washington came out. a lot of people would say Colorado residents need not apply, right? So it wasn't just for remote positions, but technically, an argument for plaintiff or for AG's offices and for the people who created these laws, they would say, if it's possible that a resident of Colorado could apply, but is willing to move, then you need to be following Colorado law as well. What is your interpretation and what would be your advice to a client?
Well, I mean, everything is on a case by case analysis. So I think it always will depend on a lot of facts. The size of the company, the kind of the position, et cetera. I would say that in general, trying to get around the laws by saying things like Colorado, California, Washington residents need not apply, that's not going to work, especially for anything remote based, or if it is, anything that is going to be performed at least in part in that state. Don't try that. Don't try to get cute. That is a good way to end up in the crosshairs of the Colorado or California attorney generals. It is not a place where anyone wants to be. Many of these states do have size requirements, as in when the law takes effect or starts to apply to you based off of how many employees you have, either in general or working in that state. That's why it's important to, if you are posting for a position and you aren't sure if the law would apply, reach out to an attorney or reach out to someone who knows, who has a handle on that. My email is always open if you just have a quick question as to, hey, can you just give me a quick rundown on when Colorado or Washington would apply? You can certainly, just reach out, ask those kinds of questions, as it really is a case by case analysis that sometimes can get very much in the weeds. But in general, I would say if you're hiring remote, I would just go ahead and include the salary range compensation in those postings. And frankly, I don't think it's necessarily a bad thing either, because if anything, I think it can be more helpful in making sure you're getting applicants that are actually interested and actually within your range of and what you're willing to offer. I mean, I'm sure every HR manager in this call can sit here and remember a time that they've spent hours talking to applicants about a potential position, only to find out that what they're asking for and what they'll consider is way outside of what you guys can offer. So, okay. Another important thing to know is that oftentimes these pay transparency laws will apply to internal postings, or they require employers to make internal postings. So if you have, let's say, 16 employees in California, or 5 employees in Colorado, you are making you post your external posting for a new position. You also need to let all of your internal employees know about this position, this opportunity. So that way they are able to, they are aware of it. And this internal posting does need to have your salary benefits information in it too. If you are trying to only hire internally in Colorado, Illinois, New York, and Washington, you need to do either an internal posting or make sure that all of your employees know about these internal openings within a certain amount of time. This is oftentimes or originally was seen as something that was just for promotional opportunities, but now Colorado has expanded that. I think most states are kind of moving away from that. And now it's just, if there's an opening in the company, you need to make sure everyone in the company is aware of that so that they want to apply for that, they can apply. So that's the first kind of pay transparency laws. The next kind, which is the next slide, is pay transparency, but not in the job posting. It's later on. So basically, these laws say, okay, you start to get applicants in the door. At some point during the process, you're going to have to disclose what the salary range, what the compensation range is for the position. As you can see on the map in front of you, This is Illinois, Nevada, Ohio, Maryland, Connecticut, Rhode Island. These all are the states that currently have these kinds of laws in place. These are also the states, or strike that. These also all cover remote positions and remote employees. When dealing with these, the timing of when you have to make these disclosures depends on the state. It depends on where you are in the hiring process. Maryland is the only one that says it's only upon request, meaning the applicant has to ask you for it. Connecticut, Nevada, Rhode Island, Illinois, that all is dependent upon where you are in the process. So Connecticut is as soon as the offer is made. It includes internal employees. Nevada is immediately after the interview or upon request for internal employees. So you get the idea that this is very nuanced and how quickly these kinds of analyses can become very, very state dependent. Once again, most of the states with these laws, if they don't already through other laws, require disclosure of the salary range and the position to current employees that are considering promotions, or may also require you give the salary range for an employee in that position if they ask for it. Even if they're not looking for a promotion or a transfer, if they ask you, you may have to give them the salary range for that position anyways. So once again, this all depends on the state. Some states require it, some states don't. And so it's important to just kind of make sure that you're keeping apprised as to what the states you're operating in will require when it comes to these things. Now, one of the questions you oftentimes get with these is, well, okay, but how do you figure out what the salary range is, right? How do we know what the salary range is? I mean, can't we just put anything between 0 and 100,000 or 0 and 50,000? Well, no, that's not how this works. It does have to be actually based in reality, based on reasonableness. And most importantly, it needs to be based on either the actual history of the position or the same position in the company, or also by looking at what's called substantially similar positions. And each state has their own test or guide on what is a substantially similar position. Most of them are looking at positions that are comparable based on the skill, effort, responsibilities, and duties. And again, you have to keep in mind that these are all designed to help eliminate the racial and gender pay gap. So that's why states now require and say, look, we want you to give realistic pay ranges, salary ranges, and make hiring decisions that are in line with what you're paying everyone else in the company so that you can ensure that there is equity across the salaries for different people in the same position or a substantially similar position. So what do you do then? If you are one of these states that now you're thinking, okay, well, I got to start making sure I'm disclosing this stuff or putting this stuff in my job postings. Well, make sure you're keeping records, first of all, of the pay, compensation history for positions. Remember, compensation includes benefits, includes mandatory or non-discretionary bonuses, commissions. Make sure you're aware as to what your substantially similar positions are. And you're keeping records on those too. And by the way, Colorado does now explicitly require you keep these pay history records for positions, or they will as soon as their amended version of the Equal Pay for Equal Work Act goes into place on January 1st, 2024. But this is also very much implicitly put into a lot of these laws where they don't directly say you need to keep records. But if you are challenged in court over one of these laws, you will need to prove that the salary range that you're giving is in line with your pay, with the history for the position and the substantially similar positions at your company. So kind of already will need to have those records in order to do that. Make sure that if you're posting something online, especially for positions that are remote, can be performed anywhere. Just include the salary range and the compensation, those benefits. And by the way, the benefits can be a link to your website where you outline what, our company offers health insurance of this type, or we have a range of health insurance offerings and we pay this amount. Here we have a 401k and we do this matching. That can be a link to a website if you have it pretty standardized across all of your positions. So you don't have to, retype that out for every single one. Again, just make sure you're keeping in mind as you hire employees across the country in new states, or as you, grow in new states, or in states you're already in, but maybe you go from 1 employee to 15 or 16. That's probably going to hit the threshold for a lot of these state laws to apply. So just keep in mind when you're going to hit those threshold and what you need to do. And again, that's a matter of working with groups like Thomas's, like Berkshire, and working with firms like ours who can help you stay on top of those things and kind of keep you briefed on those, especially as more and more states are going to continue to pass laws like this. This is a very hot trend. We've seen it in state legislatures. I'm sure we're going to see more as the years go on. So that is the pay transparency. And then the other kind of law that we're seeing in general with these are the pay history prohibition laws. I'm sure everyone in this call has filled out a job application or gone through a hiring process where you've had to disclose your salary history. And these states up on the screen, as well as Puerto Rico, which is not included on our map, sorry to Puerto Rico, they now prohibit employers from asking employees about their salary history during the interview or hiring process. So what this means is that also includes benefits, and it also includes using third parties such as recruiters to obtain this kind of information, or trying to search it out online using reference checks to try to obtain this information. You are not allowed to ask or try to obtain salary history, benefit history from applicants in these states. Now, I'm sure everyone's going to say, okay, well, wait, what if someone voluntarily tells us their salary history has been? If an applicant truly voluntarily discloses their salary histories, most states say you still cannot use this information. There are a few exceptions, but most of the time you still can't use it. And if you can, you can't use it in making hiring decisions or in salary decisions. So it's very limited in what you can do with that information. You're basically supposed to disregard it. For internal applicants, some states say that you basically need to pretend that you don't know what their salary history is. Even though they currently work for you, you're supposed to disregard that. Keep pay and salary out of mind for those internal promotions or transfers. That's not all of these states. It's just some. Again, this is a very state-by-state analysis, and I would put up 1,000 maps if I could, but I figured you all did not want to see that many different colored maps of the United States of America. So you can generally, in most states, ask applicants about their salary and benefit expectations for the position they're interviewing. But you must be careful when you're doing so. This can't be something where you're really trying to get the salary history out of them or trying to get them to start talking about that. No, this has to be really focused on what their expectations are for the salary history. For their salary expectations for the position they're interviewing for. So you want to make sure that if you are asking those questions, you're being very careful about it. And again, if you're in a state where you've already had to disclose your the salary and benefit range in the job posting, there's really not much reason to have to ask those questions anyway. So I would probably shy away from it. Just a couple of pointers on these. It's very important to make sure your human resources departments are well trained on these, as I know it's been standard practice for a long time to ask about salary history. Make sure that if you are operating in these states, hiring in these states, you are not engaging in this process, that you are have removed all of those questions from your application process, that your HR is aware, so that way employees, or I'm sorry, potential applicants, potential employees aren't disclosing things that they shouldn't be asked to. If you're hiring nationally, for remote positions where anyone could be based, I would just make sure that you've scrubbed those from your application process and you're not asking those questions at all, just to avoid having any issues with these laws come into play. These are taken seriously, are laws to take seriously. They carry with them, some of them carry fines. Some of them can be very steep fines, and those fines oftentimes increase for each violation. Citations, private rights of actions, attorney's fees. There could even potentially be, liability, potential additional employment liability if someone believes that you have discriminated against them in making an offer or a salary determination based off of a protected class. So it is important to make sure that you are staying up to date and complying with these laws. This isn't to scare you, it's just to say this is the reality, and this is why it's why we wanted to talk about this today, because a lot of people are just starting to hear about these things, and are maybe hearing more about the pay transparency for the job postings and not aware that it also carries this second issue. There are also, in all of these laws that we've discussed, usually anti-retaliation provisions built in. So that does create additional liability, and it's important to make sure that you're aware of that. You cannot retaliate against someone for refusing to disclose their salary history if they're in one of these states, or for asking what the salary range is, or the benefits are for a certain position if they are in one of these states. So that concludes with my portion of today. And Thomas, I'm going to turn it over to you.
Sounds good. And I've been watching a lot of the questions come in, so I think I'm going to be able to address a number of those with this talk. So I'm going to go a little bit out of order based upon the questions that I've seen. I think I'm going to, talk about market analysis first before I jump into job evaluation. It's a very specific, kind of thing that employers should definitely be considering if you have employees in, Washington State, California, or if you have employees in Canada. The way that it works, we'll talk a little bit more, but I'll kind of go into market analysis and why that's so important now. Because that's what a lot of employers are asking, when they come to us, and what I hear and I'm seeing in your questions as well is why do we report for a range? How do we know what to report for a range? Well, you have a tool that's available to you that's not really available to job seekers, right? You can sign a contract or do it on your own by purchasing salary survey information, and you can find out and develop a range for each one of your positions and combine similar ranges together into pay bands and pay grades and things like that. And so that's what the goal of a market analysis is to identify the market worth of a position to an organization. And there are three key factors that influence what a market's worth is. One is whether or not you are for-profit or nonprofit. That's the key thing to think through. And what I've seen over the last 3 years in market data is that the nonprofit sector in general is a lot more chaotic in a sense when it comes to market analysis than the for-profit arena. Over the last 3 years, of course, there have been, increases due to lack of supply and high demand of jobs. But the nonprofit arena is starting to notice a shift, whereas before nonprofits could focus, completely upon saying, well, you would understandably make less here because we're a nonprofit, and most of the money that we bring in, we want to go towards the cause, et cetera, et cetera. But what we're noticing in market data is that there's starting to be a shift between, to use restaurant language, front of house and back of house people. The front of house are the people that work with the clients of the nonprofit. They see the impact of what the nonprofit is doing and what they personally are doing to impact the world, to impact clients, all that kind of stuff. And so there's still a really good argument there that they are making less as a project manager or something like that than their for-profit counterparts, because they're getting additional emotional benefits from working at the company and the passion and everything behind it. The back of house people is like, HR and accounting and finance and legal and things like that. And although there is some emotional part of working for a nonprofit and being their accountant, it's not as much as the people that get to see the day to day. And so we're seeing volatility in the market data for nonprofits for those back of house positions. The second one is your industry. So what exactly do you do? Whether or not you're for-profit or nonprofit, what is your industry? And to know your industry, you can think about it as your NAICS or ICS codes, right? And so every company has that, because that's how you file your taxes. That's how the IRS knows what industry you're in. You file it with other information. So, California Pay Act, where you're giving California your pay data. EEOC, if you have to file the EEO1, Component 1, and maybe Component 2 coming back sometime soon. So you should know your industry code, and different industries pay for jobs that are different. A accountant that works for a multi-billion-dollar aerospace is going to command more of a salary than an accountant that works for an organization, like a restaurant industry that has less margins and things like that. So industry is going to be really important, and then also location, right? Location is an extremely important factor. Whether or not you decide as a company to focus on cost of labor, cost of living, or some combination of the two, right? I always use San Diego as a part of the discussion here, because San Diego has a very high cost of living. It's 1.72, the national average. But it's traditionally had a relatively low cost of labor, because organizations have always been able to say, well, you're living in San Diego, where it's basically 72 degrees year round. And so cost of labor has been low, but that's changed, right? With COVID, with a lot of work from home and a lot of other things, we're seeing a little bit of a normalization between cost of living and cost of labor. So to go back to why this is important, you've studied the job. You studied the job of accountant, and you find out that for your minimum qualifications, for who you're looking for the skill level required to be successful in the role of accountant, your pay range for fresh out of school to max out in their pay range is going to be $80,000 to $120,000. So what should you put? Should you put the entire range of the pay grade? You can. Can you take some of the advice that Liz said earlier and look at what you've actually offered over the past 5 years and max it out there and say, for what we typically hire, the minimum to the midpoint of 100,000 is what we would offer, because we probably wouldn't hire someone that's already got 20 years of experience and offer the maximum of their pay grade, because where are they going to go? Do you have a senior accountant position? Do you have a principal accountant position, et cetera, et cetera? So you want to think about what is a reasonable range to put on it. It's not $0 to $1 billion. It may be the entire range of the pay grade. It may be a shorter version of that is reasonable based upon historical data that you have related to what you have offered in the past few years, adjusted for inflation as you move your pay grades. You need to also think about, when you're doing a market analysis, taking into account your minimum qualifications. When you buy a salary survey, that is typically based upon the entire market median for everybody that is in that job title throughout the country or in your region. What it doesn't tell you is what do all the people who provided the data for this analysis and that you've purchased, what are the minimum qualifications? Because you might have really high expectations. You might be a smaller company that's not willing to hire your accountant fresh out of school. They need to have 5 years of professional experience. And so if you base it upon a pretty generic salary survey, you may find that applicants are continuously telling you that you're underpaying for your position because you're asking for 5 years of experience, but indicating that you're only willing to pay at an entry level type of position. We'll get a little bit more into the job evaluation next, but this is kind of external equity, right? You have access to this data, whether you work with somebody like us, work with somebody we would consider to be a competitor, or work on your own by buying salary surveys and creating your own internal market structure. The reality of the situation is what you're doing is external equity. You're bringing everybody in on a level playing field in the sense that they're able to see that the pay range is $80,000 to $100,000. So for somebody who's making 90, they're like, okay, so this is similar to what I'm making now, but somebody who's making 70, they know that this is going to be a nice big bump for them potentially, and that they will be able to take care of their family better or whatever. And so you're starting people off right on an even playing field for what could happen next, which is salary negotiations. And so this plays well with what I'll talk about next, which is job evaluation. So again, there are different definitions of who you should be comparing in pay equity laws. So Canada, California, and Washington specifically use this phrase that's not used in any other state law, which is comparable worth. And that's a little bit different than situationally similar, right? Title VII is based upon equal pay for equal work. Most state pay laws, and even if we're doing a federal pay equity, we would still try to do substantially similar, right? But California and Washington and Canada and most of Europe, so that's where originally the idea came from, take it a little bit a step further and say comparable worth. And the reason job evaluation is important and this discussion around comparable worth is important is because market analysis is biased. So if you go through, the research and everything behind pay equity and why there are issues with pay, it's not because somebody's sitting there going, I'm going to pay women less than men. It's not usually a conscious decision. There's a lot of things that come into play. There's differences in opportunities, but there's also individual differences in people. And we know through tons of psychological research, this is the fun part of being an industrial psychologist, that women are less likely to negotiate than men when it comes to negotiating a salary. So if a woman gets an offer and it seems like a reasonable offer, she's more willing to accept it versus a man who looks at that offer and says, I wonder how much more I can get, right? Just the way that women and men have been raised and differences in things have led to that. But what that also leads to is that female-dominated and minority-dominated roles are depressed in market analysis. So that years and years and years and decades of women not negotiating as much as men shows up in market analysis in the sense that female-dominated roles are in market analysis at a lower rate than they probably should be if women felt more comfortable negotiating, for example. So the whole idea of job evaluation is to take a different look at your data. So not just to look at it from this external viewpoint of what is it worth in my industry and my location and with my minimum qualifications, but what positions is this position most like internally when it comes to outcomes. So when doing a job evaluation, you could do what's called a point factor, in which you create compensable factors, things like accountability, responsibility, authority, mental and physical demands, et cetera, and create a matrix that has different benchmarks for low to extremely high in the need for this, so that you can create a way to compare positions that do completely different things to see what they are internally worth to you as an organization. So, for example, if you look at market analysis data, you will see that an HR generalist and an accountant get paid strikingly different things. Just to give a loose example, we may find that the HR generalist is in pay grade 14, which is, say, about 70,000 to 100,000. But we would find that the accountant would be in pay grade 16, which would be 85,000 to 120,000. But if you do a job evaluation and you look at responsibility and accountability and the need to make decisions that are concrete versus the need to follow guidelines, you might find, and most companies do, that HR generalists and accountants are more similar in their internal worth to the organization. So what California and Canada and Europe and all of these other things that talk about comparable worth would say then is that what you are doing is, in a sense, making up for the differences in the positions by saying that these have comparable worth, and you have options there, right? You could choose to lower the accountant pay grade to meet the HR pay grade. You could say, well, since this one's 14 and this one's 16, I'm going to make them both 15. Or you could say that we're going to raise the HR generalist into a grade 16 and pay what it's worth to our organization. So that's kind of what job evaluation is really intended to do. And as you add new positions and as you grow and all these kinds of things, it's an easy process to go back out, fill out the job evaluation form, and put it in with other similar positions that are comparable. Last thing that I wanted to talk about is pay equity, right? And so pay equity is really the reason why all of these laws exist, is to get to that ideal, right? So it's not wage gap. There's going to be a wage gap, and it is going to take time to fix. If we were to look at the latest estimates, for example, of, say, Hispanic females versus white males, it's going to take a little over 200 years, right, for opportunity to equalize, for socioeconomic status to equalize, for there to be as many Hispanic females getting engineering degrees, IT, all of these kinds of things, and to shun this 1950s and 1920s attitudes of things, and where everybody has equal opportunity regardless of their background. This is going to take time, but something that we could solve tomorrow is pay equity. And the reason I'm talking about this as part of this idea of pay transparency and everything else is that it's these practices, right? These well-intended practices that have led to unintended consequences that leave us here. And let me note very quickly to say that pay equity can be a very good tool, but also a very dangerous tool in the hands of the wrong people. So I would recommend that, although that my firm is very good at doing the pay equity calculations and giving recommendations, you should have counsel attached to this to protect the organization. You're trying to do the right thing by doing a pay equity analysis, and you need to protect yourself by doing that analysis and having privilege attached. But the reason this is a part of everything is that this idea of asking somebody what they make, right? Or the stepchild of that question, what would you like to make here? It extends inequities in a sense. You're not wrong for asking that second question, but it's important to understand that 99.9% of pay inequity comes from starting pay decisions. It doesn't come from performance management. It doesn't come from some people getting promoted faster than others. hopefully that's going to be solved with other things, like, for example, the Colorado law, just by making sure that everybody understands what promotional opportunities actually exist. It'll help ensure that shoulder tap promotions aren't happening anymore. And we know that in shoulder tap promotions, you're likely to have a similar to me bias effect. The manager may not be picking out the best person to get promoted. They may be picking the person they like the most. And the person they like the most may and generally does follow very similar demographics to their own than picking the person that has the best skills for that next position. And the person who had the next skills may not even have known that there was an opportunity to get a promotion until after it's announced to everybody that XYZ got that promotion. So pay inequity comes from those starting pay decisions. And in a lot of ways, the idea of saving the company money is that well-intended thing that has led to unintended consequences. If you can get somebody to work for you in a role that should probably pay about $100,000, but they're willing to do it at $80,000, then you save the company $20,000 a year. Good business decision. Unfortunately, what we know from doing pay equity analyses and from researching on this is that the person who is more likely to accept less money is going to be a minority or a female. And that's because there's a history of non-negotiation, et cetera, which technically, no, that's not your fault. But the reality of the situation is that you have access to things. You have access to market data. You know what that position is worth. And you're allowing someone, in a sense, to lowball themselves by doing that good business decision of saving the company money. So this is why we recommend to all of our clients and to everybody on this call to do a market analysis, know what the worth is of every one of the positions that you have, and to run that internal pay equity analysis under privilege, of course, to check to see if you have any evidence that these good business decisions have actually led to consequences with your organization, and have a professional help you remediate those concerns and change your policies going forward so that you're not remediating something, but then recreating it by following the previous policies. So I think we're going to be ready to specifically answer some questions.
Yes. And I was kind of going through the chat, Thomas, while you were talking and giving some really great information about how to determine, how to make these salary determinations and salary range determinations, as well as addressing pay inequity in the workplace. So I think that answered some of the questions, but I did see a couple that I wanted to just go ahead and answer. First of all, we will send out the slides with the recording. We saw some people asking about that. So that's an easy one. Yes, we can do that. Someone asked if the New Jersey salary disclosure prohibitions are already in effect. And yes, they are. Those are already in effect. I did see a couple of questions about how these laws are enforced. How does Colorado know if I've broken this law, or California or Washington? The reality is that, first of all, this oftentimes comes from people who, for job postings, they see that you're posting, you're advertising. It's a remote position. They live in one of the states where the salary disclosure is required. Meaning you have to put it in the job posting and you haven't. And it's a position that they think they could fill, so they can go to that state's Department of Labor or Attorney General and file a complaint. That's one way. If a potential employee or if an applicant is not hired and they believe that it was done so because they asked about salary, in one of these states, or because they asked about other benefits in one of these states where you're required to disclose that, that would be something they could file a complaint on. Obviously, if someone feels that they have made they were not given a job or extended an offer because they refused to disclose their salary history in a state where those kinds of questions are prohibited, or where a decision was made on discriminatory grounds, they can file complaints in those states too. And some states also allow private rights of action. So they can just go right to court and getting an attorney and filing a lawsuit in those states. So there's a lot of different ways that enforcement can come around. So that is why we say that these are not things to take lightly and try to ignore. Some states are being increasingly aggressive when it comes to going after employers or companies for violations. Colorado especially, they have started issuing citations. They have indicated that they are not going to allow employers to try to get around or escape prosecution or liability for these kinds of violations. So they're not things to just ignore. Of course, if you have any concerns, also go ahead and another great resource are the State Department of Labor websites. If you're wondering, what do I put in these? What do I have to do for Colorado versus Washington versus Illinois? The State Department of Labor websites all are putting out fact sheets and little quick FAQs that say, here's what you have to put in, here's what needs to be included. So those are great resources also for people to take a look at.
So I apologize for almost bursting out in laughter, but this question came in that I just want to go ahead and read. What is the bigger risk? Government with fines or employees with pitchforks?
I'm not quite sure what the employees with pitchforks would apply to.
Well, I'll just I think what they mean is you're if not following the law, right? Whether or not the AG or employees, and I'm gonna go ahead and equate these from my standpoint is it's a loss of reputation either way. If you're being dragged through the mud and through headlines that an AG is suing you, that is going to hurt your chances as a business. And it's gonna create a lot more internal questions for your employees to start going, why are we being sued for this? And then they're going to start looking in, and then you got all kinds of concerns, right? The other one is just as concerning, right? When people are looking for jobs, they read these things like Glassdoor and other things. And if your reputation starts to tank because of current employees, then you can be it would hurt just as much, right? Now, when it all comes down to it, if I was to equate this back to pay equity, I would worry about the class action lawsuit more than anything else. But I wouldn't, I would worry about my reputation no matter what. And so I think a lot of these laws that are coming out, and, Liz will definitely give from the legal standpoint, but I think a lot of these laws as they're coming out and as this movement continues to go, and be a movement that's been upheld. There was a huge pay equity movement in the 80s, but it died. This is a movement that is not going away. And it's all about reputation. And your new workforce, as much as people want to complain about the millennials and the Xers and all that kind of stuff, the new workforce cares deeply about these things. And they want to work for organizations that are doing the right thing because it's the right thing to do, not did the right thing after getting sued.
Right. Thomas, you're exactly right there. And that is, a great explanation. And I would also just tack on one thing. Don't think that your employees aren't already comparing their salaries. They are. And they are legally allowed to. Reminder, you are not allowed to tell your employees under federal law you can't talk about your salaries and benefits with each other. If you are doing that, stop. That is not allowed under federal law. But employees are already sharing this information with each other. They're already saying, hey, I'm making this much. How much are you making? And comparing notes. That is already happening. And so if you have concerns, if you're thinking in the back of your head, wow, we really have some big disparities in how we're paying people in the same position, that's something to maybe address now and take care of now in advance before it comes back to haunt you later on through one of these kinds of laws and a complaint being filed under that, through, a lawsuit, or just through employees, quitting en masse and the loss of reputation. So just as a reminder, if that is something that people are concerned about, then that is something that you guys have the ability to start addressing now. And Thomas has given a lot of great information, and Berkshire does a lot of great work in this area. So, please reach out to them about some of the actions that Thomas has discussed today on how to address that.
I want to cover one more question real quick, because it's something that we deal with a lot when doing market analyses. So let's say that you create your ranges based upon Denver, Colorado, which is a rather expensive place to live, and you post it, and it's a remote job. So what do you put? Well, what I would recommend putting, and I'm interested to hear Liz's thoughts about this as well, so I'll say it fast since we only have 2 minutes left. Put it. Say, here's the range, $80,000 to $100,000 based upon Denver, Colorado. Offer may be different depending on location. So if somebody from Toadsuck, Arkansas, look it up, it's a real city, Toadsuck, Arkansas applies for the role, then you can offer that person less if you consistently pay remote people based upon where they are. Anything that has to do with pay is all about consistency. Don't pay the person in Toadsuck less when you've got somebody in Monkey's Eyebrow, Kentucky that is making, and that's a real city as well, is making Denver, Colorado money. You need to be consistent in whatever decisions it is that you make. But it is okay to put a range on there and say where that range is based on the cost of living or cost of labor of Denver, Colorado.
Yeah, and I think consistency really is key, as you said, Thomas. It is a much harder to explain outliers and explain why someone is being treated differently than if everyone is being treated consistently. So I think under many states, and in general, again, I can't speak as to specifics, that application where you say, here's the range, here's what it is based off of this cost of living area, that is certainly something employers generally are able to do. Or may be able to do, again, depending on the situation. And just as a reminder, though, if you are going to base things on cost of living, that does mean that you need to be, when we say consistent, it doesn't just mean for the people who are in lower cost of living areas, but that can also impact the people in the higher cost of living areas, your Seattles, your San Franciscos, your Washington, D.C.s, your Denvers, your Austins, et cetera. So just make sure, again, if you're going to go that route, that you are ready and prepared to be consistent on both ends of the spectrum.
Well, excellent. Thank you, everyone, for your time today for this webinar. We are right at 12 o'clock, so we're going to go ahead and close it out. For any questions we didn't get to, I'm sure we'll be able to look into it and send out, some information with the webinar slides. So thank you very much for joining us.
Thank you, everyone.